All right. Good morning, good afternoon, good evening, wherever you are attending from, ladies and gentlemen. It is my distinct pleasure and honor to welcome you to the YSIAC public consultation session, virtual session on the new Draft SIAC Rules, 7th edition today. And as you would have seen from our publicity, we have tried to take a little bit of a spin on the topic just well, I suppose, to enliven not just the discussion, but also to really take it from all angles in that sense. So before I go any further, just quick introductions. My name is Samuel Leong, and I work at SIAC. I'm supervising counsel here, as well as one of the members of the YSIAC Council. And I'm very happy to be accompanied by 4 of my esteemed colleagues on the YSIAC Council. No better people to discuss important things such as the draft rules than with your friends, i.e. 4 of them here. I'll go in order on my screen. So that's Margaret, Joan Ling, who is based in Singapore and a partner at Allen & Gladhill LLP. And then with her on the red team, as you will see from their screens and very well demarcated both on our flyers and at this point is Matthew Townsend, and he is based in Hong Kong and the partner at Reed Smith. Now, coming in for the blue corner, we have Miss Zara Shafruddin, who is beaming in from Brisbane, Australia, and an associate at Jones Day. And last but certainly not least, that's also for the blue corner, that's David Hu, who's an associate at, let me try and get this right, Skadden, Arps, Slate, Meager and Flom LLP. Right. So, and he's beaming in from London. So we have a good spread in terms of geography, we have a good spread in terms of experience and expertise, and I'm deeply excited to get our event going. Again, warm welcome to everybody. Thank you very much for joining us out of your busy schedules to hear, I suppose, a different take or another take on the draft rules as we try to polish, as we try to consult and to hear, such that we can make the SIAC 7th edition SIAC rules better. As a starting point, couple of things, just in terms of welcome remarks. Of course, we all know that the 2016 rules, which is about 7 years plus old now, it really is working quite fine. The innovations made there have been quite successful. And so we just want to say at SIAC, we're not in a deep hurry to get the 7th edition out. So what we want to do is we want to get it right. So I think what I wanted to say is that the public consultation is real. The last round that we did this 7 years ago, we received over 1,000 comments. I think Kevin Nash mentioned previously, and those comments really made a tangible difference to the outcome. And so again, I want to say to not just my panelists, but also all of you watching, who I invite to provide your comments as well as your questions to the group via the Q&A function on Zoom. Please pop them in there so that we can deal with them as we go along. Truly, your comments and your feedback makes a big difference. And so we have a webpage, I think it's Rule Consult 2023 on the SIAC website. And so I welcome you to provide any further comments, any more sort of substantive comments on through the feedback function on the website as well. And the easiest way is to drop us an email on that, right? So it's an exciting time at SIAC, it's an exciting time at YSIAC, because as you can imagine, rule changes don't happen very often. And we have a great panel, we have a great lineup of speakers about to sort of introduce us through some of the important highlights in this draft rules. Taking a step back, not to be too self-aggrandizing, but really at SIAC, what we do, and when you practitioners and lawyers and in-house counsel decide to incorporate SIAC rules, what happens is that you are incorporating a set of constitutional contract terms, right? Because out of that agreement, in that arbitration agreement, you set up from nothing, a procedure by which there is a legally binding process that parties have signed up to, and that includes innovations and mechanisms that we will discuss, some parameters, timelines, and so on and so forth, including, of course, legal fictions or legal concepts rather, as competence, and so on and so forth. And so at SIAC, we don't take that role lightly, and I suppose that gives us the existential crisis to the battle that we are about to face today. And without going any further on that streak of self-importance, let me just give you the outline of the flow that we will have this afternoon in Singapore. Right. So basically, what we're going to do as part of the battle is that we're going to have basically a series of 4 mini debates on selected aspects of the draft rules, or selected changes that are going to have been proposed in the draft rules that have been released. And once each speaker introduces it, it's the other team's obligation and duty, to sort of take it down, or in terms of provide the counter arguments for why that change either isn't great, doesn't go far enough, so on and so forth. Right? I propose other changes or amendments. So we'll do that in a series of 4, and I'll just roughly the time limits of those will be 8 minutes, 5 minutes response, and a 3-minute rebuttal. And we'll do that 4 times over. That takes us a little bit past the hour. And then after that, we'll then go into a general discussion, aided by the questions that you would have given to us, hopefully, throughout the debate, on other aspects or any other sort of questions or any other aspects of the rules that may not have been covered up until that point, right? So that's the flow and the outline for today. And we will start with the red team, followed by the blue team, and then vice versa. Right. It also falls on me to mention very, very quickly that the speakers today are speaking, of course, in their personal capacities, and their views certainly do not reflect their organization's views. And more importantly, these are for mini debates, and therefore these positions have also been artificially assigned. So try not to quote them in that sense, right? So I think on that careful note, we are ready to begin the debate proper, and I'd like to first and foremost to invite our first speaker, and that's for the red team, Margaret. So please tell us what you think and why the streamlined procedure in the draft 7th edition of the rules is so great.
Many thanks, Samuel. I'll keep this short and sharp in keeping with the ethos of the streamlined procedure. So the streamlined procedure is contained in Rule 13 of the draft rules. And we, the red team, says that it's an innovative provision that ought to remain in the 7th edition of the SIAC rules. Now, this Rule 13 is all about giving parties choice. Choice to choose a more straightforward procedure, choice for a quicker process, and choice to have the arbitration conducted more cheaply. Just to start off and as a starting point, when exactly does the streamlined procedure apply? It applies when parties agree. It applies when the amount in dispute does not exceed 1 million Singapore dollars, or it applies when the circumstances of the case warrant its application. And why is it so fantastic and so great? Well, as I mentioned earlier, it offers a more straightforward procedure. It provides for the appointment of only one arbitrator. The arbitration is to be decided on the basis of submissions and documentary evidence only. Further, there are no document requests allowed. In short, the streamlined procedure is nothing like your ordinary arbitration. It's meant for lower value and simpler disputes that might not even be suitable for the expedited procedure. And just to give some contrast between the streamlined procedure and the expedited procedure. So under the expedited procedure, the cap on the quantum of the dispute is 10 million Sing dollars compared to the streamlined procedure, which is $1 million. Under the expedited procedure, you can have more than one arbitrator if the president so decides, and you have the issues again with multi-member tribunal, for instance, coordinating schedules. There's a longer time for getting the tribunal constituted. And hearings may also be held under the expedited procedure if one party so requests, and document requests may also be allowed. Now, all these additional layers are done away with under the streamlined procedure. You have something that's straightforward, clean, fast, and simple. It's how the Black Widow would do things. Quick in, quick out. Now, next, the streamlined procedure is also a much quicker process. And why do I say this? Under the streamlined procedure, parties are required to jointly appoint an arbitrator within 3 days from the date that the president allows the application for the streamlined procedure. Alternatively, the president of the SIAC is required to appoint the arbitrator within 3 days if parties are unable to do so, or if one party so requests. And I think what's pretty amazing about the streamlined procedure is that the arbitrator is required to render a final award within 3 months from the date of constitution. Now, this is half the time of 6 months under the expedited procedure. And finally, which I think is really the winner, the streamlined procedure is cheap. Now, Schedule 2, Paragraph 14 of the draft SIAC Rules provides that the tribunals and the SIAC's fees shall not exceed 50% of the maximum amount calculated in accordance with the Schedule of Fees. Now, this innovation, I feel, squarely addresses the numerous criticisms that arbitration is more expensive. It's not under the streamlined procedure. And just to give the audience an idea of some what this means exactly. So if you go to the SIAC fee calculator and you key in the amount of dispute being $1 million, and you key in there's only one arbitrator, you get average fees of about 60,000 Sing dollars. Half of that is $30,000 for a $1 million claim. I don't think you can beat that. That is a steal. In short, I think I've not used up my 8 minutes at all. The streamlined procedure is fast, efficient, and cheap. What more can you ask for? Therefore, the Red Team submits that it should be retained in the 7th edition of the SIAC Rules.
Thank you very much, Margaret. Indeed, I think my time counts 4.5 minutes, so well done on that. All right, so I realized that I missed out one thing when introducing Margaret, and that is to tell you the superhero feat that she has accomplished recently, and that I think. And there will be one for each speaker. So for Margaret, her recent heroic feat was traveling for 2 weeks with 3 young children, including a 2-month-old baby. I think that in alone, sums it all up, or said is enough said in terms of heroic feats by Margaret. So well done on that, and welcome back, by the way. Okay, so over to the blue team to respond to Margaret's wonderful explanation and exposition on the streamlined procedure, please.
Thank you, Samuel. I'll be taking this for the blue team. Before I start off, just wanted to say thank you so much to the Young SIAC Committee and all our listeners for tuning in. Good morning, good afternoon, good evening from wherever you're joining us from. While I am personally optimistic about the new streamlined procedure, I cannot lie. Playing devil's advocate, I believe we on the blue team have some doubts about how the procedure will work in practice while balancing quick and efficient dispute resolution on the one hand and upholding procedural fairness on the other. First of all, it is possible that the streamlined procedure may result in parties being unfairly forced into a procedure that they did not agree to, which strips away many of the procedural fairness safeguards that we so dearly hold near and dear to our hearts. As Margaret has helpfully outlined, party consent is not required in 2 of the 3 grounds where this procedure could apply. For instance, where the amount in dispute is less than $1 million Sing. Or where the circumstances of the case may warrant the application of the procedure. Now, while I think that it is good that the SIAC has not provided that the procedure will apply automatically where one of these criteria is met, a party still needs to make an application for it to apply. I can imagine it could be very, very difficult and possibly unfairly onerous for a party resisting such an application to effectively object to the procedure, particularly if they were ambushed with the application as part of the notice of arbitration and say that that's the first time they've even heard of the dispute. It's not a given that there's any sort of pre-arbitration notice dispute resolution procedure in the relevant contract. So this would force that particular party at a very early stage of the proceedings to decide whether to agree or object to the procedure before they've even had a proper chance to consider what their position is, what are all the issues, is there a counterclaim, what are their rights, or simply what evidence do they need or do they even have in their possession to prove their case. This risk of procedural fairness ambush is even greater where the parties involved negotiated their arbitration agreement prior to 2010, prior to when the SIAC introduced any form of expedited procedure. Those parties could have had no way of foreseeing that they may be forced into a lightning-fast Black Widow procedure without the guaranteed right of being heard at a hearing, without the possibility of obtaining relevant evidence and possibly critical evidence from the opposing side, and without the ability to rely on factual or expert witness evidence, unless, of course, the tribunal determines otherwise. But this is materially different from, say, when the SIAC introduced the expedited procedure, which doesn't strip out these procedural safeguards by default and doesn't leave the parties at the sheer mercy of the tribunal's sole discretion to allow such measures as they see fit. And as I'm sure any seasoned arbitration lawyer joining us will appreciate, tribunal discretion is not always exercised appropriately and is not, at least immediately, appealable. So on that basis, on behalf of the Blue Team, we suggest that the SIAC at least provide some form of wording to allow for a transitional application of the streamlined procedure. For example, for it to only apply to disputes arising from arbitration agreements executed after the new rules enter into force, or say from the release of the draft consultation rules, once it was in the public sphere that this procedure could potentially be a possibility. Now, I know that David has some other rebuttal points on behalf of the Blue Team. So before I pass the mic to him, I just wanted to flag one or two really vague aspects of the proposed provisions, which would be helpful for perhaps the SIAC to clarify. For example, in relation to the third limb for procedure for the application to apply, where the circumstances of the case warrant it to apply, we feel that this wording is quite vague, very broad, and could lead to frivolous applications that potentially delay the proceedings. Perhaps the SIAC might consider providing some guidance as to what such circumstances might look like in an accompanying practice note on the streamlined procedure. And on that note, I'll now pass to David.
Thank you, Zara, and thank you so much, Samuel and YSIAC for having me. Just to add on, I mean, the Blue Team does not think that the streamlined procedure is appropriate for all small value disputes. Now, the second limb of Rule 13 states that the streamlined procedure may apply where the dispute is not more than 1 million Sing dollars. Small value disputes are not necessarily simpler, smaller, or less complex than larger ones. However, these disputes do call for a proportionate approach to resolving such disputes. Now, the question is whether the rules strike that balance. For example, Rule 11 provides that the default rules for no document production, no fact or witness evidence. Now, whether the fact that that proposed change completely disposes of the need for any evidence is indicative of the perceived value of witness recollection and quantum expert evidence is a debate for another day. But witness and expert testimony may be integral to allowing a party to present its case, specifically where central issues require an assessment of oral evidence, for example, the formation of an oral contract. The subject matter is very technical and requires detailed expert evidence to educate the tribunal, or whether there is limited contemporaneous written evidence. While it may be open to the tribunal to determine otherwise, because it is the default rule, the Blue Team argues that identifying the number of witnesses and experts testifying early on by the tribunal and limiting the subject matter of the testimony is a more tempered approach and should be accepted. Now, this is already contemplated for example, in Rule 14.3 for the expedited procedure. And the IBA rules on the taking of evidence also contemplate that the tribunal has the power to do this. So on that note, the Blue Team submits that there might be further revisions that could be made for the streamlined procedure. Thank you, Samuel.
Thank you, David. And Zara, thank you for very, very good points and suggestions as to what could be done to better strike the balances, as you have pointed out. So over to the Red Team now for the final round of reply in terms of the points that have been covered by the Blue folks.
Many thanks, Samuel. So I'll be doing the rebuttal. Right. Just 3 or 4 quick points. First, I don't think it can be said that parties have been unfairly forced into having the streamlined procedure. I think when you sign on to the SIAC rules, you roughly have an idea of what provisions are inside, what the procedures are. I do agree, however, for there to be a transitional provision, right? Which, because parties might not be aware of this new provision if they enter into the arbitration agreement at the time the old rules were in existence. Second, I think, the risk and the difficulties about, getting critical evidence within such a short space of time are perhaps overstated because, as I mentioned, the streamlined procedure is meant for simpler and more straightforward disputes. So I think in terms of evidential difficulties, it shouldn't be a hurdle against the introduction of the streamlined procedure into the 7th edition of the rules. And third, David, I completely agree that not all simple and low value disputes are suitable for the streamlined procedure. You could have a $50,000 claim that perhaps involves novel issues of law. And I think that's why the SIAC very, very cleverly, if I may add, had 3 scenarios under which parties could have their dispute submitted or handled in accordance with the streamlined procedure. And that's where the circumstances are appropriate and if they agree. So that, in a sense, is the carve-out. Although I think I'm going to put Samuel in a bit of a spot by perhaps asking the SIAC to, elaborate on what exactly, circumstances, appropriate circumstances are. And then finally, just wanted to add that, yes, the default position is that the arbitration is to be decided on the basis of witness statements. Yes, there are short timelines, but nonetheless, there are adequate protections in the current draft rules. So for instance, if you look at paragraph 11 of Schedule 2, it says, unless the tribunal determines otherwise, after considering the views of the parties, the arbitrations shall be decided on the basis of written submissions, etc. So there is that carve-out to protect parties from not being too rushed, from having their day before the tribunal. And also for the final award, although there is a 3-month timeline provided for the tribunal to render its award, that timeline may be extended by the registrar. So that's all I have. Over to you, Samuel.
I was going to reserve my comments to the end, but I would point out, just as a comparison, in the current 2016 rules, the equivalent provision for the expedited procedure says exceptional urgency. And that's not proven to be too helpful, because the idea of exceptional urgency, such that in terms of expedited procedure applications that have succeeded on the grounds of exceptional urgency, haven't been too many. They've been few and far between. And so we found that perhaps broadening it may have been a bit more helpful in terms of getting it to a bucket where the dispute is over $1 million, which of course $1 million Singapore dollars, as we know, is a bit of a proxy for the complexity of the dispute, right? It's not and as you said, it's not a perfect proxy, but it's a bit of a proxy, as well as one that's sort of wide enough to encompass sort of different scenarios that don't necessarily fit into the exceptional urgency bucket. But that's all I'll say for the moment. But maybe the wording could be further streamed. But I do like the idea of a practice note, perhaps giving some analogies or some examples of what may count as a case warranting the application of the streamlined procedure. Although of course that would necessarily have to come from the mind of the president, right? Because it is the president who ultimately holds that discretion in deciding whether or not that any particular case, any particular application for the SP, as we call it, the streamlined procedure, should be granted. But thank you very much for what was a very enthralling debate on the streamlined procedure. I think we're going to close debate number 1 and go on quickly to topic or debate number 2, and that is going to be proposed by the Blue Team, specifically Zara, and it will be on the proposed preliminary determination provision. And so before I ask Zara to go ahead, Zara's recent, I'm not sure how long ago this happened, but Zara's heroic feat was after having been mugged was it in Brisbane? It was in Brisbane. She, on a hill, she chased the mugger down the hill. Well, it would have been more heroic uphill, but never mind. Down the hill, and actually got her bag back from the said criminal. So well done. You truly are a hero, Zara. And on that note, let me invite you to take the floor for the preliminary determination provision, please.
No worries. I should probably caveat that I was a much younger person when that happened 2 decades ago. But anyway, we are where we are. Yep. On behalf of the Blue Team, I'm delighted to introduce and put forward our favor of the SIAC's proposed preliminary determinations provisions. But perhaps before we dive into the nuts and bolts of the proposal, I know that there can be a little bit of confusion about what exactly is a preliminary determination. Well, fundamentally, for everyone who's joining us, it is a decision made by a tribunal, typically in the form of a partial final award, on some but not all of the issues in dispute, and without having to go through all the usual procedural steps and hearings in the entire case. The aim of the process is to decide early on in the arbitration an issue that can either help to streamline the rest of the arbitration by, say, narrowing the list of issues in dispute For example, determining key issues of law, which will set the tone for the rest of the arbitration, or perhaps even disposing of a substantial part of the arbitration or the arbitration entirely, such as deciding questions around the tribunal's jurisdiction or the arbitrability of the claims. Another benefit of the process is that sometimes an early binding determination on some issues in the dispute can bring the parties to the negotiations tables and encourage them to settle their dispute amicably. So depending on who you ask, that's either a good thing or a bad thing. But anyway, now at this point, you may be wondering what the big deal is around having this new proposed provision. It's not a new concept. The current 2016 rules allow a tribunal to bifurcate proceedings by Rule 19.4 and to make separate awards on different issues at different times, thanks to Rule 32.5. Given these powers, parties do and have made applications for determination of preliminary issues under the current rules. But what the SIAC have now done is to introduce a clear procedure for parties to apply for a determination of a preliminary issue. So let's take a look at the procedure, which you can find in Rule 46 of the SIAC's consultation draft. First of all, the new rules allow a party to apply to a tribunal for a preliminary determination of any issue in the arbitration on 3 bases. 1, where the parties agree to preliminary determination, or 2, where the party seeking preliminary determination can demonstrate that it is likely to save time or costs and lead to a more efficient and expeditious resolution of the dispute, or 3, where the circumstances of the case warrant such preliminary determination, whatever that means. The Blue Team think it's quite helpful that the SIAC have not sought to provide an exhaustive list of where preliminary determination can be granted. While they've provided some guidance, the grounds are ultimately quite flexible and give the tribunal broad discretion to decide the application based on the contours of the case at hand, which ultimately is one of the salient advantages of the arbitral process, isn't it? Second, the draft rules require an application for preliminary determination to set out the facts and legal basis supporting the application. This requirement is welcomed, as it should, hopefully in theory, accelerate the tribunal's consideration of the application in that they won't be waiting for separate submissions from the applicant on why the application should be granted, for example. Third, the tribunal must then decide whether the application for preliminary determination is allowed to proceed, and if so, the parties will be given the opportunity to be heard. While not specifically stated in the new rules, one would anticipate that this will mean parties will be allowed to serve submissions on the preliminary issue together with relevant evidence, and a hearing may be held. And finally, where an application seeking such determination is allowed to proceed, the tribunal must make a decision on the preliminary issue within 45 days from the filing of the application, unless the registrar extends the deadline, and the tribunal may make their decision in a summary form. The Blue Team think this is incredibly helpful, that the SIAC want to set a tight deadline for deciding preliminary issues, as in practice, it is unfortunately not uncommon to see parties use motions for preliminary determination as a means to delay or even suspend proceedings for an unknown period of time. At least in one case that I've seen, a preliminary issue on a somewhat simple question of applicable law, or what you would anticipate to be a simple question, resulted in pushing out the procedural timetable for the whole dispute for almost a year, which involved months of arguing about granting the application for preliminary determination, then submissions on the preliminary issue itself, a hearing, and then, of course, twiddling one's thumbs, waiting for the tribunal to actually issue their decision. And these are very busy people, so it can take a while. By having some timeframes set by the SIAC and allowing the tribunal's decision to take summary form, this will hopefully result in a more expeditious consideration of such issues, while still allowing the SIAC the ability to extend the deadline if necessary. Now, while the Blue Team is in favor of the new provisions, this is not to say that preliminary determination is always appropriate or that there aren't serious risks with such determinations. As we've recently seen in Australia, there have been cases where the splitting out of issues in an arbitration has led to very lengthy litigation, now ending up before the High Court, which in Australia is our apex court, questioning issues that were carved out for a first phase of the proceedings, and then whether related issues were raised in a subsequent stage and how they should have or should not have been dealt with by the tribunal. So needless to say, if not done carefully, any form of bifurcation of proceedings and issues, including preliminary determinations, could lead to a very complex challenge later down the track, raising all sorts of issues, ranging from the tribunal's jurisdiction, admissibility of remaining issues, or even res judicata arguments. But when it's all said and done, the Blue Team strongly believes that the SIAC's introduction of the framework for preliminary determination, which is a procedure that already exists and is already used, will bring this potentially very helpful case management tool to the forefront and hopefully leads to more expeditious and efficient dispute resolution going forward. So on behalf of the Blue Team, we warmly welcome the new provisions and we hope to see them included in the new set of rules once they're released.
Great, thank you very much, Zara. That's compelling, if I may add, exposition on the proposed preliminary determination provision. So now over to the Red Team for your response, please.
Thank you very much indeed. Now, I believe we are supposed to introduce ourselves with a superpower, and I think those of you seeing me on the screen might be forgiven for thinking that I have the superpower of camouflage, given my skin tone and the contrast with the wonderful SIAC background, but I can assure you I do not have that superpower. But right now, advancing as we have been asked to, the skeptical view on preliminary determination, I would do so, or the Red Team, I believe Margaret can share responsibility for this, will do so on 3 grounds. First, on the grounds that the procedure will be rarely used. Second, on the rather mean-sounding ground that it is unnecessary. And then third, on the possibly unfair ground that it is overly prescriptive. So taking these in turn, the early determination procedure, we on the Red Team, for the purposes of this debate, consider will be rarely used. And indeed, early determination has been called in a very good Kluwer arbitration blog post by our colleagues Mino Han and Arjun Solanki, has been called the secret recipe for arbitral efficiency. And it's my submission that the word secret is used advisedly here, because all you need to do is look at the statistics of the different institutions which have implemented this kind of procedure. Taking, for instance, the LCIA, in 2022, a year in which there were 333 new cases for this institution, there was only 1 application for early determination, which was granted during that year. Taking the HKIAC statistics, in the same year in which there were 334 new cases, no applications were granted for early determination. And then perhaps even, again, possibly unfairly, taking the example of early dismissal, which is a slightly different, but nonetheless similar in some senses procedure, per the SIAC statistics, in 2022, a year in which there were 357 new cases, I believe, there were no early dismissal applications granted. So as you can see, this may be a secret recipe. In fact, one might argue it is too well guarded a secret, perhaps like some family secret recipes, a case in which we all agree that the dish is delicious, but none of us have actually eaten it. And it's the Red Team submission, and it's no surprise why this is the case. We're all familiar with procedural fairness concerns. Those of us who are counsel look at the tribunal and we are suspicious that there may be due process paranoia. Those of us who sit as arbitrators, particularly those of us who are early in our career as arbitrator, are extremely keen to avoid doing anything which might result in us rendering an unenforceable award. And as a result, tribunals might err in favor of a full process in which every point is fully canvassed and determined, and both parties are fully heard on absolutely every point. So on that basis, and to conclude this first point, the theoretical benefits of preliminary determination, we 100% agree, including those raised by my friends on the Blue Team, when it comes to, for instance, bringing parties to the negotiation table, etc. But unfortunately, these theoretical benefits are just that. They are theoretical if the procedure is not going to be actually adopted. Now, of course, if I wasn't so skeptical, or if I wasn't in the role of skeptic, I might admit to a certain selectivity in choosing my statistics, for instance, disregarding some of the pending claims and concentrating on the ones that are actually determined. And I might also be inclined to be a little bit more charitable to what, after all, is a new procedure, which has only been adopted in the last iteration of these rules. But I am not taking that line. I'm the skeptic. So moving on to the second point, the early determination procedure we say is unnecessary. And this is because the right to early determination, to seek an early determination and for a tribunal to make an early determination already, as my friends on the Blue Team have already mentioned, exist. Existing rules allow the tribunal to bifurcate proceedings under, as I believe was mentioned, Rule 19.4, and to make separate awards on different issues at different times, and under Rule 32.5. So again, from our perspective, the reform all the reform would do would be to codify an existing practice, and we would submit that's unnecessary. Now, this point has already been made very kind of wisely by my friends on the Blue Team, and they say that, well, the procedure already exists, but this kind of codified procedure would offer a clear process and guidelines. Well, that takes me on to my third point, which is that, well, yes, it does, but we say that this process is overly prescriptive. In particular, Draft Rule 46.4 provides that the application shall be determined within 45 days of the application being made, a time frame which we would submit is way too short to allow for submissions from each party and a tribunal determination. And such a short time frame in my submission will only make arbitrators who are already spooked by due process considerations to become even more cautious in deploying the procedure. So on that basis, to wrap up, possibly not early, the early determination procedure will, we say, be rarely used, will be unnecessary, and finally, is overly prescriptive in its current form.
Thank you, Matt. Anything further from the Red Team? Just to check, Margaret? No. Okay, great. So over to Zara and David for the reply, please.
All right. Well, I just have three very short rebuttal points, and I'll take it in the order that Matthew addressed them. First and foremost, in terms of the actual utilization of the procedure, I hear the Blue Team hears Matt's points around the statistics concerning the low use of the procedure, although it should be noted that some of the statistics, particularly around early dismissal, should be taken with a grain of salt, as it is a materially different procedure based on different grounds. Although one might argue that perhaps one of the reasons why the statistics are so low is because no other arbitral institution, as far as I'm aware, so expressly addressed preliminary determination and put it, dab smack square on paper. So maybe it's the correlative reaction there. And so once it is in the rules, we might see an uptick in cases. As to Matt's second point, in terms of the necessity of the procedure, as we've on the Blue Team have acknowledged, the procedure does exist already, and that while the framework might not be strictly necessary, if I may borrow the wise words of the SIAC president herself at the recent SIAC symposium, the new rules are, as she termed, spine-stiffening provisions. The specific inclusion of a provision for preliminary determination could encourage tribunals, particularly less experienced tribunals, to at least consider the utilization of the procedure, which may lead to more efficient case outcomes. Only time will tell. And finally, in terms of whether the rules are overly prescriptive, and specifically addressing the point about the 45-day period, I think anyone who's acted as counsel could agree that, yes, 45 days is quite a tall order. I think the concern about that being a very crunched timetable is adequately met by the SIAC's lovely caveat at the end of the provision of 46.4 that ultimately it's a 45-day period unless the registrar extends the time. So there is that flexibility. You're not 100% locked in.
Great, thank you.
No, that's it from us.
Thank you, Zara. Thank you to the Blue Team. I think that's a great sort of all-round view of the preliminary determined provision, and nothing further, nothing new to say. That yes, it's clearly an existing case management tool. I think, as you said, Zara, but it's one that we are trying to highlight in the forefront, such that parties and tribunals are aware that it can be used, and when used appropriately and effectively, it can perhaps result in some savings in cost and time, I suppose. But thank you for that. Now we are halfway through our debate section. I just wanted to remind everyone listening that we have Q&A. We will have a Q&A section, a general Q&A section later. And so if you do have any questions, please feel free to pop them in to the Q&A function on Zoom. Now, our third speaker will be from the Red Team, and as you would have guessed, it is Matthew. His heroic feat, in addition to, well, semi-camouflage in correct lighting, is I believe he's told us he's a bit of a sacrificial peacemaker. In the last 3 cases he's had, they've all, by wave of his fingers, they've all settled. So he's able to bring peace to very disputant and very combative sort of commercial parties. And so on that note, Mr. Peacemaker, I invite you, Matthew, to tell us about the introduction of the list procedure for appointments by the SIAC president.
Thank you. Yeah, of course, that's a very slightly ironic superpower. The new procedure under Rule 19.8 is, I think, a very useful one, which is upon the request of a party, the president may consider the use of a list procedure to make an arbitral appointment, whether that be of a sole arbitrator, presiding arbitrator, or tribunal in a multi-party arbitration. And under this 19.8 procedure, you could say there are 3 phases. First, the president provides the parties with a list of 5 candidates to consider. Second, the parties will be entitled to strike one candidate off, to each strike one candidate off the list, and then to return the list with their order of preferences within 7 days. And subsequently, the president is to make the appointment. I believe I've clarified that procedure, but I'll be corrected by Samuel. So there are a few points to make here. The first is that the list process only applies, as I mentioned, on the request of a party. And the president has the discretion, as I read it in the rules, as to whether to deploy this list procedure. That's the first point. The second point is that the procedure only applies in respect of the president's pre-existing powers of appointment. So, for instance, where the parties have failed to agree upon a sole arbitrator, the power to appoint then moves to the president, and upon the request of a party, the president may elect to use this procedure. And I should also mention that the procedure is a similar one to that adopted in other rules. For instance, the UNCITRAL rules, most recent iteration, include a similar procedure whereby the parties are provided with a list of 3 names, which can be ordered by preference with no limit on the number of deletions. So similar, if not identical. So on this basis, the Red Team consider that the list procedure is a very useful measure to introduce an additional element of conciliation and cooperation into the tribunal appointment procedure without tying the president's hands or introducing new mandatory steps which will trip everybody up and slow down the procedure.
Thank you very much, Matt. And that's a good sort of outline and introduction of the list procedure. And that is, as you said, it's a new feature. So it's something that hasn't existed in the previous editions of the SIAC rules, and it's something that, again, as far as appointments are concerned, it's quite exciting. And again, I'm sure everyone attending and yourselves will agree that there's nothing more important in the arbitral process than the appointment of the appropriate and correct arbitrator, of course. So on that note, Blue Team, please, your response.
Thank you, Samuel, and thank you, Matt, for that introduction. Here in the Blue Team, we actually welcome the introduction of a list procedure. And at the heart of it, it's about giving a greater stake to parties in the constitution of the tribunal. But we argue that if that is the intended purpose, then the proposed change doesn't go far enough in two respects. First, I will focus on the fact that the SIAC precedent communicates the list of 5 names to the parties, and then I will go on to discuss how this applies in circumstances where it is upon a request by a party. Now, as you've already mentioned, Matt, the list procedure starts with a circulation of 5 names. Now, this is the most important step because it is the starting point for parties to participating in this process. If the parties are familiar with some of the candidates, then fine, there is no issue there. However, if a party finds itself in a position where it is given 5 names that it's completely unfamiliar with, then it may not be appropriate. None of these candidates might be appropriate for the dispute from the party's perspective. And in that sense, the Blue Team argues that there is no meaningful improvement in party autonomy. If this change is truly intended to promote party autonomy, parties should be allowed to exchange lists instead. And the Blue Team suggests an approach. The parties will exchange a list of 3 names each. The parties nominate a common name if there is a common name on both lists, failing which each party strikes 1 name from the other list and ranks the remaining 4. Submits their short list of 4 to the president, and SIAC can pick from the final short list of 4. Now, the Blue Team argues that there are 3 benefits here. First, or 3 benefits here over the proposed change as drafted in the draft rules. First, parties will be able to select candidates that they consider to be appropriate for the dispute, and will also have the opportunity to consult with their party-nominated arbitrators. Parties which opted into the list procedure want more of a say in appointing the tribunal, and this revised approach goes much further in giving them a meaningful voice. Second, parties will have a higher chance that their proposed candidates are selected because the final shortlist will contain at least 2 of their candidates, as opposed to, and that's 50%, as opposed to a 0% chance if they're completely unfamiliar with all of the candidates on the SIAC's list of 5. And third, finding a common name on both lists might also save some time in the appointment process, which takes at least 7 days. Second, moving on to my second point, SIAC is entitled but not obliged, as you rightly pointed out, to use the list procedure upon the request of a party. This might make sense where the use of the list procedure is disputed by the parties for valid reasons. But the current framework means that SIAC may not decide to use the list, even if both parties agree to it. The Blue Team submits that the list procedure rule should be strongly encouraged, particularly where both parties have agreed to do so. And the draft rule allowing the precedent to override the party's agreed mechanism where there is an unequal treatment in the enforceability of the award provides a way to deal with situations where the use of the list procedure may not be appropriate. Now I'd like to pass on my time to Zara in case she has any further comments.
Thank you, David. I wholeheartedly agree with your proposals and only wish to add another suggestion, if we may be so bold. That is, if the case were to resort to the president making an appointment and a list procedure to be adopted, which we are in favor of, if the parties are not permitted to exchange their own lists first, as David has proposed, then one alternative option would be to allow for the SIAC to build into the procedure a precursor step for the parties to be allowed to submit at least one name for inclusion on the list. It may be a name that was canvassed between the parties already or an entirely new candidate. There need not be any limitations on that name. Either way, this will ensure that the list circulated by the president isn't entirely alien to the parties and allows the parties to still have a voice in the process, all in keeping with bolstering party autonomy.
Thank you very much, Matthew and the Blue Team. Just very quickly, Zara, your idea was for each party to be able to input one name into the list. Is that right?
Yep.
Okay. Yeah. No, it's always a fascinating balance in terms of allowing for equality, and then of course you always have to put on that lens of a non-participating respondent, right? And so if you lock yourself into a list procedure, irrespective, then now you're sending a list to someone who's just ignoring you entirely, and then of course that drags on the process. So it's striking that balance, but that's an interesting one that you are arguing for parties to exchange lists as opposed to a neutral originated list, which I think it's a model that UNCITRAL and SIAC is proposing to follow. But those are interesting points, especially the point about having a list that's totally alien to the parties, and then not having the ability to strike them all off, I suppose, which I think as Matt pointed out, we are prescribing in the current form of the draft. No, wonderful. That's great. I mean, again, no more important aspect as far as appointments go in terms of the rules, and this is a big new change. So that's something we're happy to give it a proper think, and we may come back to it later in the questions, I think. All right. So now down to our fourth mini debate, and this will be introduced and proposed by David of the Blue Team, and this relates to the specific proposed additional ground for consolidation, and that's the ground of common question of law or fact arising out of or in connection with all of the arbitrations that are sought to be consolidated. This is found in Rule 16.1 C Roman 4, as well as 16.9 C Roman 4 of the draft rules. Before I give the floor to David, now his heroic feat of recent years, well, again, recent is relative, sorry, is that he participated again. So David has a superhero fascination. So he participated and completed the Singapore Standard Chartered Marathon in an Iron Man costume and face mask. The face mask bit is particularly crazy. And he was running next to Thor, I believe. So I haven't seen photographic evidence, but I take it that he did finish, and that maybe a picture of the medal will ensue. But well done, David, on that count. And so over to you to tell us about the proposed additional ground for consolidation, please.
Thank you, Samuel. I'm happy to share photographic evidence with a more limited audience, if time permits. But on to greater things. The Rule 16 of the Draft SIAC Rules, the Blue Team submits, is a welcome change because it provides an additional ground for consolidation on the basis of a common question of fact or law across the arbitrations. Now, just in terms of how I will introduce this change, I will start by explaining this change in the context of the power to consolidate ongoing arbitrations. And then I will talk about the three virtues of this change. Firstly, that it leads to substantial savings in cost and time. It eliminates the risk of inconsistent decisions, and it generally improves the quality of the decision-making process for the parties. And really at the heart of this proposed change is efficiency and improvement in the quality of the arbitral process. Now, Rule 16.9 of the draft rules enables the tribunal to consolidate arbitrations in one of three situations, just for some context. First, where all the parties have agreed, where all the claims arise out of the same arbitration agreement, or there is the same tribunal in both arbitrations or only one tribunal has been constituted. And in the third scenario, the scenario that we're concerned with, where the arbitration agreements are compatible, the same or only tribunal has been constituted, and where there is some element of commonality. Now, as we have explained, the proposed change relates to the third and final situation. And here, just to break down the third limb, arbitrations will be consolidated where the arbitration agreements are compatible. In other words, they're either identical, provide for the same institution, seat, number of arbitrators, appointment procedure, the same or only tribunal has been constituted, and there is some form of commonality between the arbitrations. And how commonality is assessed is under the existing 2016 rules, that the disputes arise out of the same legal relationship. The disputes arise out of related contracts where you have the principal and ancillary contracts, or the disputes arise out of the same transaction or the same series of transactions. Now, multi-party, I will now move on to the benefits of this proposed change. Multi-party transactions are becoming increasingly common, and the arbitration community has witnessed a rapid growth, not just in Singapore or in Asia, but throughout the world. The increasingly specialized and complex nature of international commerce has led to a proliferation of multi-party transactions. And so it is really inevitable that disputes involve multiple parties and multiple contracts. Now, consolidation along with joinder and other mechanisms in the SIAC toolbox play a crucial role in addressing these complexities and enhance the quality of the arbitral process. Taking each of the benefits in turn, resolving related claims in a single proceeding leads to substantial savings in time and cost. When you have two arbitrations combined into one, you avoid the need for duplicative submissions, evidence, hearings. But more importantly, and this leads to my second point, it eliminates the risks of inconsistent decisions and inconsistent relief. And often this leads to unfair outcomes for all parties involved. This also improves the quality of the decision-making process for the parties, because when related factual and legal issues are heard together by the same tribunal, this provides the tribunal with more context. And this is particularly the case in highly technical arbitrations that require specialized knowledge, such as IP disputes or areas in tech, for example, where the tribunal has to get over a huge amount of information and often a lot of expert evidence. Hearing those disputes together in one arbitration results in better decision making. And for that reason, the Blue Team welcomes the proposed change by the SIAC and agrees that consolidation on the basis of a common question of fact or law should remain in the rules as published. Thank you.
Thank you very much, David. An excellent introduction to the proposed sort of sub-ground for consolidation. Now over to the Red Team for your response, please.
Hi, many thanks. To be frank, I was struggling to come up with a response for this particular topic. I think the advantages that David has articulated, I mean, they are advantages which apply to provisions for consolidation in general. I think the crux is whether there should be a provision for consolidation where there's a common question of law or fact which arises out of or in connection with all the arbitrations. To me, like I said, I agree that such a provision should be included. The only hesitation that I would have is whether it's a bit uncertain. What does it mean when the provision states a common question of law or fact arises out of or in connection with? It seems a bit broad. It seems to be a bit uncertain. But other than that, to be honest, I don't have any critiques of the provision. Any critiques would be common to any provisions on consolidation in general, not just this provision.
Thank you, Margaret. Matthew, do you have anything to add? Okay. We have. Would the Blue Team like to respond to that very collegiate reply by Margaret. Yeah.
Thank you, Margaret. Yeah, I agree. I think that, I mean, the SIAC rules go further than the HKIAC rules, for example, because the HKIAC rules require all, we talk about the 4 disjunctive requirements of same legal relationship, related contract, same series of transactions, or common question of fact or law. Now, it is interesting that the HKIAC rules says that all 4 requirements must be fulfilled in order for consolidation to occur, where consolidation arises out of multiple arbitration agreements, in addition to the fact that the arbitration agreements must be compatible. So I think SIAC is a bit bold here. If I could be if I could be a bit honest, and I would say that I think they're really pushing the boundaries of efficiency and improving the arbitral process. But for all the reasons I've already described, I think as long as there is a common question of fact or law, it just leads to better efficiency, and that's what people sign up to when they choose to apply SIAC rules to their dispute. Thank you.
No, thanks, David. Zara, anything to add at this point? Okay, no, that's great. So that's a wonderful segue and juncture for me to close the debate section. So you can take off your red and blue team hats right now, and so I think we have about 28 minutes to go for us to have, I suppose, without artificial impositions of positions, some discussion. Again, the participants, audience, you're welcome to add any questions that you may have to any of the speakers. And so this part, you're not constrained by positions taken in the last hour. But this is an excellent segue to this part of the program, because interestingly, I think we've gotten, SIAC has run this consultation process for a couple of months now, and actually this ground has not gotten as positive a response from most of the other sessions as compared to what we've heard. And I think one issue is it goes too far. That's the common critique, that it goes a bit too far, where unrelated parties can all be consolidated into a single arbitration proceeding on the basis of this potentially on the basis of this ground. And one sort of shorthand in terms of describing this was it leads to class action arbitrations, because as you will see now, if you did a search online, you will find that I think that there are large internet companies, I think Amazon's one of them, where SIAC rules are already incorporated in their sort of template terms and conditions. And so you could then see where there's an outage, where there may be a common occurrence hitting a bunch of consumers, where that could then lead to potentially sort of a class action type. So I was just open the floor right now to maybe David, since I suppose that you've done the most reading around this rule. Is that a step too far in terms of allowing for class action type? And if so, maybe SIAC should broadcast it a little bit brighter in headlights, if that's the purpose.
Well, I mean, I think as I said, I think SIAC is trying to be quite bold with this proposed change. The question is whether the commonality is sufficient. I think we all agree that related claims should be heard together, whether that is through the coordinated proceedings, because the coordinated proceedings also has this ground as a proposed change, right? Or whether that is only appropriate, or whether that is appropriate for consolidation. As to your point about the prospect of class action arbitrations, I mean, that could be a risk, but the way of alleviating that risk is to increase the commonality requirement, right? It is really a spectrum between efficiency in the arbitral process and improving the arbitral process and in party consent, right?
Yeah.
And you're always trying to find that right balance. I don't know exactly where the balance lies, but perhaps one suggestion is that you could have a requirement where you have at least 2 of the 4 factors met, as opposed to just 1. That could be that could be one suggestion. I mean, I'll be happy to hear other views.
Yeah. Does anyone else on the panel like to chime in?
One point about the possibility of class arbitrations under standard terms of service between one provider and multiple users or multiple customers is that it's often in these types of terms of service you will find an exclusion or a provision whereby class arbitration is excluded. I also imagine, although I haven't had to look at the issue myself, whether one user's agreement with the platform and another user's agreement with the platform would be considered to be arising from the same transaction or series of transactions or whatever the appropriate test is.
Yeah.
So I can see there being issues arising in that regard.
Yeah, no, exactly right. So hence the only way you can get a class action is on the sole scope of subground 4, which is the one that David was talking about, because you probably won't get it under 1, 2, and 3. So this is Roman numeral 1, 2, and 3 of Rule 16.1 sub rule Charlie for those who are following. So they are not disputes that arise out of or in connection with the same legal relationships. They are not disputes arising out of the contracts of consisting of a principal and an ancillary, and they are not disputes arising out of a transaction or a series of transactions, because they are all sort of separate, basically different claimants, right, against the same respondent. So the question is whether it's in that specific category, whether or not that's a good way, it's a good move by SIAC to allow different claimants with of course the next question, of course, is confidentiality, in terms of sort of allowing everybody within the same scope or the same warm blanket of confidentiality, as we might say, in terms of one proceeding. And so big questions, and so that we've had some pushback in terms of maybe that's going a bit too far. Margaret, Zara, go ahead, David, please.
Sorry, I didn't mean to butt in, but on the point of confidentiality, I mean, you could say that there is a difference between the disclosure to the parties to the arbitration, the consolidated arbitration, and disclosure to the public at large, right? I think there is a true loss of confidentiality where it is disclosed to the public at large, but I don't know whether, I mean, I think some commentators have argued that the loss of confidentiality is relatively low when they're only disclosing to the two parties, and even more so if they're related claims,
right,
and related parties, then that's even less of a problem.
Right. No, I take the point. So yeah, it would be a sort of a limited disclosure in that respect. Zara, yeah.
Oh, I was just going to say, to tap onto that point that David just raised, there might be a slightly different consideration where you're dealing with listed entities and they have reporting obligations and the degree to which they have to report.
Yeah.
I've seen a whole raft of range of some of these disclosures, and some are more detailed than others. So perhaps tread lightly when dealing with public companies.
I see. Okay. No, thank you. Warning well received. No, absolutely. Of course, our confidentiality exception under the rules existing and proposed, I think makes it very clear that if the listing rules requires disclosure, then that of course is an accepted exception, I think, to the confidentiality rule, right? Yeah. Okay, great. So I mean, now it's basically we're going to move to a bit of a more organic discussion, as we have already on the consolidation rule. So I suppose open question to one further change, which I think we haven't discussed yet, is the changes to the emergency arbitrator procedure. So the emergency arbitrator procedure, I think it was introduced in 2010 by SIAC. It was the first Asian institution to do so, and again, it's been immensely successful. And there has, well, you might suggest that there has come in time with some legislative changes in certain jurisdictions, which has now expressly provided for enforceability of EA or emergency arbitrator awards as well. So that's been very exciting on our part. And so there has been some tweaks to the EA procedure, which I'll just quickly go through and for everyone's benefit, and then maybe we can have a discussion about whether or not that's good enough or whether or not that's too far. So on the EA procedure, right now at present, an emergency arbitrator application must be filed either concurrently with a notice of arbitration, which commences the arbitration, or after the notice of arbitration has been filed. With the current draft changes that position to where the EA application can be filed prior to the notice of arbitration. And I think within 5 days, the notice of arbitration then has to be filed and then the case properly commenced. So that's change number one. Proposed change number one. Proposed change number two is that the deadline for the emergency arbitrators award, instead of, I think, 14 days under the current rules, comes down to 10 days, which will then include from appointment of the emergency arbitrator, the award on or order on the application needs to be granted needs to be decided within 10 days from the date of appointment. And so I'm going to open this to well, I'm just going to ask Margaret if you have any views, and anyone else can feel free to chime in on whether or not these EA changes to the EA procedure are welcome. Yeah.
I think the First Amendment is definitely a welcome to give parties, more avenues in terms of who they want to seek interim relief for. But I think the timeline of 10 days really puts quite a lot of pressure on the arbitrator. I really wonder whether it's necessary to shorten the timelines to that extent. It'll be interesting to know, I guess, perhaps for the audience and for myself as well, what was the rationale or to shorten the timelines to 10 days.
Great. So I've got a return, sir, for myself. Anyone else has any comments? But I'll take that for now. I think the idea was looking at our stats. The emergency arbitrators were actually excelling. Basically, the average timeline was well shorter than 14 days. So given that the EAs were already meeting the deadline well in advance, we thought maybe we could move the bar a little bit since it was already. But you're not alone, Margaret. There have been various comments that said 10 days is going a bit too far. Give the arbitrator and ourselves, SIAC, to do this, because we have to do the scrutiny, of course, the weekend, because I think 10 days just gives you one set of weekends. But if you do 14, you I think on all accounts you get two. So that's one comment that we've received. But actually, the EA stats have been quite encouraging in terms of emergency arbitrators having been able to complete it. Of course, I invite comments from the perspective of the respondent. So if yours slapped with, okay, Matthew, please.
Yeah. Well, absolutely. I mean, I've been involved in a sole emergency arbitration as respondent, so I have firsthand experience just of how. On occasion, it can feel like the scales are a little bit tilted away from you as respondent, given that although the application should have been brought as an urgent application, so you would assume it would have been brought very, very soon after the circumstances leading to it arose, the claimant or the applicant does have rather more time. So I guess you might be concerned about the time allotted to the arbitrator, but also bear in mind the respondent's time to respond, given this might be the first time their counsel have heard of this issue.
Yeah. So 10 days, you think, Matt, is going a bit too far? You might want 30 days.
But 10 days is more challenging than 14 days. But
yeah, no, fair enough. Yeah, and of course, it's striking a balance, tweaking numbers. There's never going to be a perfect one. But Zara, you have your mic on.
I was just going to say it's a luxury compared to the SEC, which has 5 days. That's a tall order.
Yeah.
But yeah, I have a great deal of sympathy for respondent counsel and also actually the emergency arbitrator.
Yeah.
I must confess, though, I've only been on the claimant side of an EA several times, and I've enjoyed the claimant position very well.
Okay. Yes. I mean, it's almost the unequal positions of a typical wedding proposal, right? Where the prospective groom has all the time in the world to get ready, and then the bride has to say yes or no, sometimes in public. But we won't dive into sort of those wedding norms at this point. So that's an interesting point. You guys are not alone. The EA procedure and the tightening of the timelines Some have said, look, spare a thought for the respondent, spare a thought for the arbitrator and for SIAC staff who have to do the scrutiny, I suppose. And maybe 14 days. Maybe it doesn't need to be tightened further. I suppose that's one way to look at it. I suppose any other changes that you would like to speak of, please shout out. Otherwise, I'm going to go on with my list. Yes, and that's basically the codification of this existing practice. Again, on talking about existing practices concerning the neutral nationality of the sole or presiding arbitrator that's appointed by SIAC. So that's, as you may know, and as our audience members may well know, that's something that's already being done in practice almost always at SIAC, unless parties agree otherwise, or there's some specific circumstance. And so now the question is whether or not codifying it helps that process. Because so I was wondering whether or not you have any views on whether that's a good move or not a good move. I think one comment is that the English Act, in their considerations for reformation, I think decided not to codify it. So that's maybe one data point I'll put out there. And maybe David, you have some views on this point.
Yeah, I mean, I think ultimately the question of on the proposed change to the English Arbitration Act, it's about hearts and minds, right? You're trying to change attitudes with this proposed change, and the question is whether the rules are the best place to start with that. Mm-hmm. At the end of the day, if you are ultimately, if the rationale behind this proposed change is about changing attitudes towards arbitration and giving of the nationalities a greater ability to participate in the process as arbitrators, then the question is whether the arbitral rules are the best place. I'll be happy to hear other views.
Mm. No, thank you. So that's something that we've again seen different practices from different institutions, as well as different law reform initiatives in terms of. I think one. Sorry, anyone else has any comments? One comment is nationality. What do you mean by nationality? The parties nowadays, as you've mentioned, David, come from all over and have all sorts of layers, and so that brings another ground of challenge and complexity as well as vagueness. So if anybody wants to jump in, feel free to unmute on this point. Otherwise, I think the next thing we're gonna go through a bit of a list of Samuel Leong's bugbears. One comment that we've received, and this is a sort of a broad one, is that the draft rules are long. They're in incorporating a whole bunch of new procedures and mechanisms and introducing some innovations, they've become quite long. And so then one question is, what can we cut? And again, this is specific to me, and I'm taking the liberty as moderator to propose it, and I'm inviting your views, please. Is what do you think of the idea that there really is no need for any provision in the rules to deal with tribunal-appointed experts? So not party-appointed experts, but tribunal-appointed experts. I suppose I'll start with this. Like, among the four of you, hands up, or please let me know if you've ever had a case where there was a tribunal-appointed expert. Zero. Oh, okay. So Zara and Matthew, you've both had it. Whereas Margaret, none? And David, have you ever? Yeah. So okay. So I mean, Zara and Matthew, I suppose I'm going to turn to you now. And was that helpful? And is there something that the rules need to expressly address? Zara, please.
Okay.
Oh, sorry.
I will say in the instance that I was involved in one, I was sitting as a tribunal secretary, so assisting the tribunal. Mm-hmm. And in the void of having any particular guidance under the applicable rules, they found the CR protocol very, very helpful as a gap-filling tool. So when I look at the new provisions that have been proposed, I do query it because I haven't seen them used very often. Mm-hmm. And I think it would be in very highly technical cases. And I just can't imagine that there's just more often than not, you'll have party appointed experts and they'll fight it out between mm-hmm. themselves. But sometimes you end up in a position where maybe you have three experts, one for each party and one for the tribunal.
Yeah.
So having some guidelines would be helpful, but I must confess, I haven't done any sort of detailed comparison between what's proposed and, say, the CR protocol.
Yeah. So,
so
did it save time and cost in the end? I mean, so yeah, Matthew, if you feel jump in as well, but did it save time and cost in the end having a tribunal appointed expert? I mean, yeah.
Yeah, at least in my experience, I think the arbitrators found it helpful to have sort of effectively a shadow expert that they were able to talk to about tricky issues. But I don't really know if we can quantify if any sort of saving was derived from it.
Okay. No, Matthew, yeah.
Sure. I mean, my experience is quite similar. In my case, it was a highly technical case involving alleged misappropriation of technology. So, of course, you have both sides' experts, or each side's experts advancing a very kind of different explanation of what the technology was, whether and how it had been misappropriated. I wonder, my experience in this, I've only been involved in one case, but I wonder if actually the appointment of a tribunal expert, it might seem to somebody who's unfamiliar with the process like a move of kind of like a kind of more passive move, but actually I think it's quite a robust move for a tribunal to say, actually, we want to have an expert who will advise us on the different, do a deep dive into both experts' opinions. And certainly the tribunal which appointed a tribunal-appointed expert, in my case, was an extremely robust one. There was no concern about the tribunal becoming kind of hostage to the expert and excessively relying on their own experts' assessment without testing their assumptions and methodology. So I wonder if on the assumption that it's quite a confident move by experienced tribunals, then that would be a reason why you maybe don't need mandatory rules regulating how that robust and experienced tribunal goes about that business. Right.
No, yeah, certainly. Yeah, Margaret, Dave, if you have any views, feel free to jump in. I suppose where just to put it in context, I suppose right now there are express provisions, or at least in terms of recognizing that the tribunal appointed experts can be done, including that then their fees counts as part of the cost of the arbitration, for example. But in my view, that is so rarely used that it may be something that could be taken out, given the complaints about length, I suppose. Any other views? Margaret, have you ever wished that you had a tribunal appointed expert in a case? I mean, there already is enough, contention and debate about hot tubs, and then trying to get experts from opposing poles coming together. Adding one more to the mix, I suppose. Rarely happens, and I haven't seen tribunals been too keen on doing that. I suppose Matt and Zara's cases are the exceptions rather than the norms.
I guess one additional point is that often in the context of tribunal secretaries and the roles that they play, I've heard tribunal members or experienced arbitrators say, look, you, the law firm, have the benefit of a number of junior staff who are helping you, with legal research, etc., and you are leveraging that. If my tribunal secretary is very delimited in the role they can play, well, maybe that's a little unfair. I guess by the same token, you might have tribunal arbitrators who might say, well, hang on, the parties have an expert, maybe even in larger cases, two experts, one testifying, one advising. Why can't we, the tribunal, who ultimately have to bear the responsibility for this determination, have the same, benefit? I see what you mean. That's of course, those experts also have a team behind them, right? In terms of doing the raw calculations and the homework behind it. Margaret, you had something to add.
Yeah, I mean, for me personally, I wouldn't be too keen for a tribunal to appoint its own expert. I want to have a say as to at least my expert arguing it, and I know who the other side's expert is, and we can object or whatever. I think when it comes to the tribunal appointing its own expert, we'll have less say. I mean, that expert is not someone that the parties would have appointed, it's just adds a layer of complexity for me.
Yeah. So certainly with you, David, please.
Yeah, I mean, I just in terms of the rules being too long, I wonder whether it is better placed as a practice note, actually. that it doesn't have to be part of the rules. It can be something that the parties consider, or if they consider to be useful. Because as Margaret and Matt pointed out, there are some instances where tribunal appointed experts might be helpful, but there are many other instances where it might not be helpful or warranted by the parties.
Yeah, and of course, going against, unless by consent. I mean, that's a whole different world of pain if the tribunal proceeds to appoint one over and above the party's objections. I can imagine that. Yeah, that's rare. That would be a rare instance, I suppose. Yeah, but again, Matt's point about the role, well, the imbalance between tribunals in terms of the resources available to it compared to the firms and the legal teams before it. That's certainly a perennial point that's raised. And I mean, just having to deal with recently calculations of interest up to the day, calculations of various quantum figures, it would be useful in that sense for a tribunal to have, tribunal's accountant, I suppose, to do the math to make sure that that it crosses the T's and dots the I's in terms of the quantum before it's sort of put on paper and signed and then finalized as a binding award. But no, that's a good point. I think we're coming to the tail end of a lot of time, and I suppose it's a good point. It's a good point in the program to go with some quick hitters. So just again to introduce to our audience some of the other changes that have been made. The SIAC expedited procedure since 2010, again, humongous success, and it's been used. I think, what was it, almost 800 applications today. Sorry, the numbers fail me right now, but it's been very, very popular. But interestingly, the acceptance rate, i.e. the granting of the expedited procedure, hasn't been, may not be as high as you would think. It's around about 60%. I think just from a rule back of the envelope calculation. So not every application for EP, as we call it, that's our existing fast track procedure, goes through. And so right now, the proposed change to our very successful EP is to increase the monetary threshold. Again, it's an imperfect proxy for complexity, but it's now going to propose for it to go up from 6 million Singapore dollars to 10 million Singapore dollars. Now, anybody thinking that's a bad thing? So your silence is consent, and I agree. I mean, generally, I think it's universally accepted that it's an appropriate change. Just in terms of widening the use of the expedited procedure. Let's put inflation aside, but 10 million is an appropriate monetary threshold now, as well as because there is the idea that the streamlined procedure may come into play, which then shaves off the disputes that come in under 1 million, right? So then it's sort of horses for courses in a more nuanced way. The other change that we're going to make that we're proposing to make to the expedited procedure provisions is, again, the one we've discussed earlier. So instead of exceptional urgency as a ground for application for an EP procedure to apply, the proposed change is to where the circumstances of the case warrant the application of the expedited procedure. And to quote Zara, whatever that means. But I suppose, again, the idea that it is broad, and it's broad for with some intention, that is a wide catchment for a judicious application of the discretion by the president. So again, round the virtual room, any thoughts, any objections to this change?
Yeah, just one small point. Is part of the rationale that because of the publication of redacted awards, that will create some form of reference for parties to refer to when the circumstances warrant such application.
Right. Yeah. So in due time, as we are able to develop a corpus of redacted published SIAC awards, then that would give parties some guidance. Of course, bear in mind that that's the award of the tribunal, so that's not necessarily grounds given by Lucy or any SIAC precedent on the application per se. At the moment, SIAC practice that the EP application decisions are not reasoned, so parties don't have a reasoned decision, so to speak, in terms of their expedited procedure applications. Yeah. So, but of course, then if it was granted under the EP, you can then reverse engineer it and look at it and say, so a case like this, which ended up like this, you could say is fit for the expedited procedure. Right, so that's on the expedited procedure, and the other one I was going to was the one exactly that you brought up, David, which is the default opt-out for consent to publish. I mean, being able to publish redacted awards is a thorny thing, and it's a bit of a NIMBY thing, not in my backyard. So everybody agrees it's a great thing, except not for my case, right? So publish everyone else's, but leave mine alone. And in that world, yeah. So I mean, as counsel, I'm going to go around the room, right? So Margaret, do you think you can get your client to consent if it wasn't opt-out, i.e. it's opt-in? So we're changing. If we had to get consent, do you think you could ever get a client to consent to publication of a redacted award?
I think in most cases, no. I mean, clients are not going to bother to come back to you, right? They're just going to say, oh, arbitration's done and dusted. I don't want anything else to do with the dispute.
Exactly. Yeah. Assuming enforcement is great, but yeah, exactly right. So other than an opt-out, I'm not sure. So I'm just going to carry on. David, do you think you can get it from your most progressive client?
No, I think it's a tough call. I mean, again, it's there's no interest. They have absolutely no interest to do so.
Yeah, Zara, could you sell it? Could you sell it to your client?
There are certain clients of mine who, when they've won, they're very happy and they're very happy to shout it from the top of the rooftops. But I would caution. I mean, I'm very much in favor of publication of redacted awards, and I was a big fan of the SAA series from 2012. So I'm showing my age here, and I was very sad when I never saw a second volume come out. But my question mark is perhaps have it as opt-out, but perhaps the SIAC should provide a draft of the proposed redacted award for comment, just to ensure that there's nothing that's slipped, and at least put forward, like circulate the draft, and if the parties don't respond, that is be taken as they've consented.
Okay. No, that's a good point. So circulate, but not for approval, but for reference.
Well, they're given a period to object, and at least point something out. Like
So right now, I think the current rule does provide for them the ability for them to object. I mean, but without having seen the draft. But I think your point about let's give them the draft. Well, being sitting from the point of view of the person likely to have to do the draft and then see it get objected to is a bit painful. But I get the point. Matthew, we're going to end with you. Do you think you could sell your best client to get them to consent?
I think it would be challenging, and I wouldn't call it so much a NIMBY problem as a kind of tragedy of the commons problem, which is that it's an asymmetric proposition. If they don't do it, then if they do it, then there may be some kind of risk which will materialize, as people kind of identify their case through deduction. But if there's if they do provide it, then the only real benefit they're giving is to the accumulation of greater kind of decided decisions. So I agree. Parties tend to be more willing to shout from the rooftops where, for instance, they're listed and they have to make some kind of disclosure and they've won. Then they might lean on that to give a more fulsome disclosure, as fulsome a disclosure as permitted.
Yes. And in those cases, often unredacted because they want you to know that they've won.
Well, exactly. Slightly different point.
Yes. On that winning note, ladies and gentlemen, I think we have come to the end of our time. I've thoroughly enjoyed our session. Thank you very much for joining our battle test of the new Draft 7 edition, proposed Draft 7 edition of the SIAC Rules. Again, my thanks to Margaret, to David, to Zara, to Matthew, to everyone who's present, and to the SIAC team who have supported this event from the back end. Thank you very much once again, and I wish you a wonderful rest of the day. See you, everyone. Thank you. Bye.
Thank you.
Thank you. Bye.